Morning students, this is Sreekanth, Assistant Professor, Dr. Ambedkar Global Law Institute, Tirupati. Yes, signing in for company law. So, you know that for every company, what are the two important documents? One is Memorandum of Association, another is Articles of Association. Remember, you have to prepare invariably, compulsorily, mandatorily these two important documents. One is Memorandum of Association, another one is Articles of Association. Right. We have seen what the Memorandum of Association contains. It contains name class, registered office class, object class, liability class, capital clause, and association of subscription clause. We have analyzed in our previous class what is meant by memorandum of association. In fact, it is the constitution of the company. If anybody goes beyond memorandum of association and articles of association, it is ultra vires. We have seen what is meant by ultra vires also. Right now, we are going to see the second important document. It is known as Articles of Association. So, Articles of Association, it is briefly called as Articles, and it is the second important document that has to be filed with the registrar at the time of registration of the company. You have seen memorandum contains 6 classes. Now, what is meant by articles of association means articles of association contains rules, regulations, bylaws for the internal management of the company. It contains rules, regulations, and bylaws for the internal management, how you are going to manage the company, everything that has been said in the articles of association. Why you are framing these rules and regulations? For the purpose of carrying out the objects of the company that has been stated in the memorandum of association, right? So whatever that has been stated as objects in the object class of the memorandum of association, you have to carry that objects in accordance with the articles of association. So this is the second important document. It contains rules, regulations, and bylaws for the internal management of the company, and it is subordinate to and controlled by the memorandum of association. That means articles of association cannot bypass or go above the memorandum of association. Companies Act, under the Companies Act, memorandum of association will be there. Under both the Companies Act and memorandum of association, you have to frame the articles of association. That means it is subordinate to the memorandum of association as well as the Companies Act. If there is any conflict between articles of association and memorandum of association, memorandum of association will prevail over articles of association. Likewise, Companies Act will prevail over memorandum of association and articles of association. So, articles of association is subordinate to and controlled by the memorandum of association. Memorandum of association lays down objects and powers of the company. Articles of association lays down the modes in which you are going to execute that objects of the company. So the articles of association contains rules, regulations which are framed for the internal management of the company. This document is subordinate to the memorandum of association. Now these rules and regulations, remember, you cannot put any rules and regulations in the articles of association. Remember, The rules and regulations must not be contrary to the provisions of the Companies Act. Right? Now, every company may frame its own articles of association, or it may adopt Table F in the Companies Act. If you take Companies Act, there is one Table F is there. It's a pro forma articles of association. You can adopt the Table F as your articles of association, or you can frame your own articles of association. So two choices will be there. You can frame your own articles of association, or what you have to do, you have to adopt Table F. If you go to Companies Act, there will be schedules will be there will be tables will be there. If you see Table F, it contains a pro forma articles of association, and you can adopt the Table F as your articles of association. Now, the question arises is whether every company has its own articles of association or not. Let us see. So, articles of association is legally compulsory for these type of companies, private limited companies. They should have a compulsory articles of association. Unlimited companies, they should have articles of association. Public companies limited by guarantee, they should also have articles of association. But it is not obligatory for the public companies limited by shares. So a public company limited by shares may either frame its own articles of association or adopt the rules and regulations contained in Table F of the Companies Act. So, three alternative courses will be available to a public company limited by shares. Number one, it may adopt Table F in full, or it may partly set out its own articles and adopt part of Table F, or it may wholly exclude Table F and set out its own articles. Right? So, these articles of association play a very important role in the management of affairs of the company. The Companies Act contains many provisions under which company can act only if it is authorized by its articles of association. So many provisions wherein there are so many provisions in the company, but you can what is called go through over those provisions unless and until it is authorized by the articles of association. So let us see what are those provisions wherein the company can act only if so authorized by its articles of association. To issue redeemable preference shares, articles has to authorize. To accept calls in advance from shareholders, articles has to authorize. To increase share capital, articles has to authorize. To consolidate and divide share capital into shares of larger amount than existing shares, articles of association has to authorize. To convert fully paid shares into stock and to reconvert that stock into fully paid up shares, articles of association has to authorize. To subdivide the shares into shares of smaller amount than is fixed by the memorandum, articles has to authorize. To reduce the share capital, articles has to authorize. That means certain provisions of the Companies Act can be enforced only if it is authorized by the articles of association. So the memorandum of association and articles of association, these are the two basic important documents. Remember, you are going to register the same with registrar of companies. Once memorandum of association and articles of association has been registered with the registrar of companies, it will be put in the website and it assumes the character of a public domain. That means If you want to deal with Reliance, then what you have to do? You have to go through the memorandum of association and articles of association. That means for any company, remember, if you buy shares of a company or subscribe for debentures or whatever it may be, it is nothing but a contract between you and the company. So whenever you are entering into a contract with any company, you have to see these basic documents. What is the documents? Memorandum of association and articles of association. Memorandum is the constitutional document. Articles is subordinate to and is controlled by the memorandum of association. So let us see the contents of articles of association. Contents of articles of association. So you know that articles of association of a company contains the rules and regulations which are framed for the internal management of the company, and such rules and regulations are contained in the articles of association which are necessary to carry out the objects. So if you see the articles of association, you will be noticing definition of important terms and phrases like adoption or execution of pre-incorporation contracts. We have seen what is meant by pre-incorporation contracts. Pre-incorporation contracts are those contracts which are entered into by the company that has not yet come into existence. So promoters will enter into pre-incorporation contracts, and if the company adopts the pre-incorporation contracts, company is liable on those contracts. If the company don't adopt the pre-incorporation contracts, promoters are personally liable. So in the articles of association, they will insert a clause. In the articles of association, they will insert a clause. Yes, the company is going to adopt pre-incorporation contracts. That means articles has to authorize the adoption of pre-incorporation contracts. Next one is share capital and the rights of the shareholders. So share capital means what is your authorized capital, what is your issued capital, what is your subscribed capital, paid up capital, reserve capital, different types of capital will be there, and what are the rights of the shareholders. Once you purchase shares in the company, you will acquire certain rights. Shares always carry with it dividend and voting rights. Remember, shares will be having two rights. One is dividend. If you purchase shares, the company will pay you dividend. And second one is you have a right to vote in the meetings of the company. So what are your rights? Whether the shares carries only dividend or the shares carries voting rights also. Next, allotment of shares. How you are going to allot the shares? If the allotment of shares that has been prescribed in the articles of association is not followed, then it is ultra vires. So articles of association defines how you are going to allot the shares to shareholders. Now procedure as to making of calls on shares. Calls on shares means, for example, one share is rupees 10. At the time of making an application, you are paying rupees 2. Yes, then after allotment you are paying 2 rupees. That means you have paid 4 rupees. Still your liability is 6 rupees. Whenever the company wants money, it will again ask you to pay another 2 rupees. That is known as calls on shares. Right. Now, if you don't pay the calls on shares, whatever be the amount that has been paid on the shares, it will be forfeited by the company. For example, you paid 4 rupees, the company asked you to pay another 2 rupees, you didn't pay, then they will forfeit your 4 rupees and they will allot the shares to somebody else. So this is known as forfeiture of shares. How the company is going to forfeit your shares. Next, transfer of shares. Transfer of shares means how the company is going to transfer. Here, two terminology will come into picture. One is transfer, another one is transmission. Transfer means voluntary, transmission means by operation of law. Transfer means A is there. A wants to transfer his shares to B. That means A is voluntarily transferring his shares to B. It is known as transfer. Suppose A dies, automatically its shares get transferred to his son. That is known as transmission. Transfer is voluntary. Transmission comes by operation of law. Right? Next, lien on shares. That means you have learnt in contracts lien, general lien, particular lien, special lien. If you don't pay or if you are indebted to the company any amount, then they will have lien on your shares. Then manner of issuing share certificate and share warrants. How they are going to issue share certificate and share warrants. Then alteration of share capital. How they are going to alter the share capital. Now, conversion of shares into stocks. How you are going to convert the shares into stocks and reconversion. Then, provisions with respect to dividend, reserves, capitalization of profits. This will also contain in the articles of association. Appointment of managerial personnel, that means directors, whole time directors, how you are going to appoint the directors. Next, meetings will be there. How you are going to conduct different types of meetings like annual general meeting, statutory meeting, extraordinary general meeting, class meetings, creditors meetings, how you are going to conduct the meetings. Then borrowing powers of the company, whether the company can borrow. This provision has to be inserted in the articles of association. Accounts and audit. Again, articles will contain the provisions with respect to appointment of chartered accountants, conduct of internal audit, statutory audit, so on and so forth. Common seal of the company. What is the common seal of the company? Voting rights, proxies, till winding up of the company. Even winding up procedure is prescribed under the articles of association. That means, remember, whatever that has not been contained in the memorandum of association, then articles of association will contain the same. Very simple. Whatever that has not been contained in the memorandum of association, everything articles of association will contain. If you remember my previous class, I have told how to convert a public company into private company and a private company into a public company. So private company contains some restrictive clauses. Restrictive means restriction is placed on the private company. If you place restriction in the articles of association, it is a private company. If you remove these restrictions in the articles of association, it is a public company. So, the articles of association of a private company must also contain three statutory restrictions. Statutory restrictions means restriction that has been imposed by the Companies Act. Number one, restriction on transfer of shares. Remember, private company cannot transfer the shares. Now, second restriction is restrictions on membership. Remember, maximum number, minimum 2, maximum number should not exceed 200. Remember, if the members exceed 200, automatically it becomes a public company. Third restriction is restriction on issue of prospectus. That means you cannot invite the public to subscribe for shares or debentures. So, articles of association of every private company must invariably contain these three restrictions. What are those restrictions? Restriction on transfer of shares, restrictions on membership, maximum number should not exceed 50, minimum must be 2, restrictions on issue of prospectus. That means there is a prohibition on invitation to the public to subscribe for shares or debentures. Now, you know that articles of association contains the rules, regulations and bylaws for the internal management of the company. Now, the company may alter its articles of association at any time by following the prescribed procedure in the Companies Act. So, company may alter its articles of association by passing a special resolution. So, in the meeting of the members, if you pass a special resolution, you can alter your articles of association. Again, even if you pass a special resolution also, you have to get approval from the central government, right? Even after passing the special resolution, you have to get the approval from the central government for certain things. That means you have to pass special resolution and you have to get approval from the central government simultaneously for two things. One is alteration which has the effect of converting a public company into a private company. So if you are going to convert a public company into a private company, special resolution plus approval of the central government. Now the alteration which has the effect of increasing the remuneration of any director, including a managing or whole time director, also you have to get special resolution plus approval of the central government. So now altering the memorandum is very difficult. As a matter of fact, company can alter its articles of association as a matter of right. That means the Companies Act gives a clear and statutory power to the company to alter its articles of association, right? However, it should be within the provisions of the Companies Act. You can alter the articles of association. It is a right given by the Companies Act. Remember, you cannot alter memorandum of association that much easily. It requires a lot of formalities and procedures. You can alter articles of association. So if you want to alter the articles of association, you have to pass a special resolution. So the alteration must not be inconsistent with the provisions of the Companies Act. You can alter the articles of association, but it should be within the provisions of the Companies Act. The alteration of articles which is inconsistent or contrary to the provisions of the Companies Act is inoperative, yes, and without any legal effect. So it is inoperative and without any legal effect. Next one is, that means the articles of association must be consistent with the provisions of the Companies Act. Second one is, the alteration must not be inconsistent with the memorandum of association. So alteration of articles which is inconsistent or contrary to the provisions of even memorandum of association also, it is inoperative and without having any legal effect. That means alteration of the articles of association should not go beyond the powers given by the memorandum of association. If the alteration sanctions an act which is otherwise legal and is not clearly prohibited by the memorandum, alteration will be valid and operative. So alteration of articles, it should not go beyond the Companies Act, it should not go beyond the memorandum of association. Again, the alteration of articles must not sanction anything which is illegal. By inserting a clause in the Articles of Association, you cannot do an illegal act. The alteration of the Articles of Association which sanctions any illegal act is inoperative and without any legal effect. That means it should not be unlawful or forbidden by law of the country. For example, gambling is forbidden by the law of the country. Now, a company, by special resolution, altered its articles and added a clause authorizing the directors to allow gambling in the office building after working hours and to earn commission thereon. In this case, what happens? Alteration is invalid as it sanctions an act which is illegal. That means you cannot do illegal acts by authorization in the Articles of Association. Next one is alteration must not constitute a fraud on the minority shareholders. There is a majority shareholder, minority shareholder. So you cannot commit a fraud on the minority shareholders by inserting a clause in the Articles of Association. So alteration of Articles of Association which constitutes a fraud on minority shareholders, it is inoperative and without any legal effect. So articles cannot be so altered as to deprive the minority shareholders of their rights. So you cannot deprive the minority shareholders of their rights. Next one is alteration must not increase the liability of the existing shareholders. That means, for example, if you are going to purchase one share is rupees 10, your liability is only rupees 10. By inserting your articles, you cannot tell that not only 10 rupees, you pay additional 2 rupees. That means you cannot increase the liability of the existing shareholders. The alteration of articles which increases the liability of the existing shareholders is inoperative and without any legal effect. But you can do one thing. By alteration of articles, shareholders cannot be asked to pay more than their liability. But if they agree, you can alter the Articles of Association. That means liability of the shareholders cannot be increased in any way unless and until they agree in writing. Right? Next one is alteration must not cause or operate as a breach of contract. So the alteration of articles which enables the company to commit a breach of contract with third party is not justified and company may be held liable to pay damages. Right? So these are the ways in which you can alter the articles of association. And lastly, the alteration must be made in good faith and for the benefit of the company as a whole. You can alter the articles of association, but it should be made in good faith and for the benefit of the company as a whole. If it is not made in good faith and for the benefit of the company as a whole, it is inoperative and without any legal effect. An alteration which is made in good faith and for the benefit of the company as a whole shall be valid and operative even if it is likely to affect adversely or adversely the interest of some of the shareholders. Right? So you can alter the articles of association subject to the above provisions. Right, students? Got something today? This is Sreekanth signing off today. Have a good day, children.